I'm going to try to tell you in these minutes what was the evolution of Latin America towards the Ibero-American system, which follows the model of the EU. For that point, I will go up before I go towards the last century and to see what happened when the 20th century was finishing and the certain milestones, and then how it is today. Okay? So first, what was happening at the end of the 20th century? In what means to the constitutions, we had, in general, no express recognition for the right of data protection. An example of that is my country, Uruguay. But most countries did provide a constitutional protection for the right of privacy, as Colombia did. Some constitutions also provide means of enforcement, such as an habeas data action. That is the case of Brazil, Paraguay, and Argentina. If we speak in terms of law, there were no general laws on data protection except for two cases. Chile, in 1999, passed a law that is called a general law, but if you study it, you can see that the first article says, well, this is a general law. The second article says lots of exceptions, and the third one, lots of more exceptions. So, well, no general law in Chile, even though it is called like that. It's not comprehensive of all data protection issues. In Argentina, yes, there was the law in 2000. There is in all Latin America a common background of laws and regulation that consider data protection as a right that is inherent to human condition or that derives from the republican form of government. In that sense, data protection is included, was included, and is included. As such, in that sense, we can mention Chile and Peru as examples. Well, in what concerns to international instruments, that is all the same, so we don't need to. There were, yes, sectoral bills in what concerns to health, to genetic statistics, children's data, credit records, and professional confidentiality. If we speak in Uruguay in 2000, we can say there was no specific regulation on data protection on the Constitution, but we did have two articles, 72 and 332, that declare that the list of rights that appear in the Constitution that does not exclude others that are inherent to human condition, as said before. So it's a numerus apertus system in which data protection can be included. There were also sectoral dispositions regulating medical data, statistical data, and others.